Yes.
Before the short adjournment, my Lord Justice Nugee asked me whether I was right in what I was saying about paragraph 19 and 20.
Yes.
And the short answer is my Lord was quite right. I was conflating Regulation 19 with what happens in the gap between paragraphs 19 and paragraph 20. And the position is accurately set out in Mr. Hickman's statement. So if I can take the court to that, it's Supplementary Bundle, tab 17 at page 515. And can I ask the court please to read paragraphs 24 and 25. So it confirms my Lordship's understanding as put to me that it's not necessarily at that point that there'd be a decision to cull, but in fact in all of these cases that was the position. And the judge dealt with this at paragraph 21 of her judgment.
And if you look at paragraph 31, where Mr. Hickman deals with each of the various claimants, you can see there's something called a disease case conference. It happens quite quickly after the confirmation that it's present, but that's the actual point at which the decision is made. And that is a discretionary decision under paragraph 5, as you pointed out.
It is.
Pointed
Quite
out.
right. Yes,
Yes.
that's correct. The second question that was put to me was by my Lady Justice Laing, and the question was, well, does the Minister really have to go through that process of asking himself, am I going to condemn under this paragraph or that paragraph? And the answer to my lady's question is, of course, the Minister could simply rely on the general power. Because there is a general principle, when you have two powers that you can use to the same end, it's up to you to determine which one, providing, of course, that you don't use a general power where there is a specific power. And indeed, we'll see that's what happened in this case, because on the evidence you just saw, the decision to cull was made before the assessment of the disease status of the animals was taken, because it was done in reverse order. That was the paragraph 23 and 24 that we just saw. But the consequence of that, in my submission, is not that that categorisation doesn't matter, because what Parliament has done, again, it comes back to the submission I made at the outset, is that what Parliament has done is not to prescribe a general power to cull and then deal with compensation in a quite detailed scheme, where it's done the opposite. It's set out quite detailed sub-paragraphs delineating, and this is not just in the case of avian influenza. As we saw, it's within all of the sub-paragraphs in the schedule, which powers you have, and then the consequences that follow from it. So I agree with my lady, the Minister might, and indeed here did, just say, I'm exercising this broad power to cull. But the consequence still is, but save for those poultry that are diseased poultry, there is an entitlement to compensation. I'll come back to, again, deal with that when I make my submissions overall on Sir James's appeal. But that is my answer to that question.
Yes.
So where we were is we've just seen paragraph 19. Paragraph 20 of we're here now in tab 43 of the Authorities Bundle at page 1397. And I'll take this quite quickly from here. Paragraph 20, as we've seen, is once the decision has been made, there is a obligation, a duty of result on the Secretary of State to ensure that the animals are killed without delay. In paragraph 21, you see they can be moved somewhere else for the purpose of culling, but only, as we'll see, for the purpose of culling. Paragraph 22, you can ignore for the purposes of this appeal, because we're not concerned with the premises that are dealt with there. And if I could then ask the court please to turn to page 1436. You see regulation 82 gives some very broad powers. 83 powers of inspectors in the event that there is default. Paragraph 84, personal liability of body corporates, and then paragraph 85, enforcement. And this is an answer. Well, it's not a question, but it was an assumption that my Lord Justice Nugee made, that there would be criminal liability if these things weren't complied with, and this is the provision that fixes that. Your Lordship will see that, and your Ladyship will see at paragraph 85. It's at 85.3. There is a reference to section 73 of the 1981 Act. You don't have that in the bundle, but I hope the court will take it from me that makes it a criminal offence to fail to comply with any requirement of the Act or orders made unto it. So that's the criminal liability. So that's the face of the order. Then we have the two schedules. So you have Schedule 1, which starts on page 1439. So that's the next page. And the court will recall that happens. This is the schedule that has effect once there is a suspicion of avian influenza. So there's a set of highly restrictive measures that apply on suspicion. Then I'm not going to take the court through that. Then if we turn to page 1442, the court sees that there is Schedule 2, and this is the schedule that applies where there is confirmation. So as a matter of fact, what occurred in this case is, as you saw from the evidence, the decision to cull and this schedule coming into effect, effective notification of that was provided to the farmers, the keepers, at the same time. So this tells you what you can do with the animals once the order the decision to cull has been made. And the punchline is really nothing except to assist with the culling of the animals. So paragraph 1 tells you you've got to assist any person exercising a duty in respect to the cull. And then there are further provisions about minimising the risk of biosecurity. Paragraph 3 is important because that tells you that all carcasses and eggs not seized or disposed of by the inspector have to be disposed. So that's telling you that to the extent that you might think that you'll be able to exercise any residual right over the property of anything that's related to the chickens, well, that's not correct because you've got to dispose of it all. And then paragraph 4 is about tracing. So this is that's what happens alongside the order to cull. And there was no dispute below as to how they operate in practice. So James took you to paragraphs 18 to 25 of the judgment of Mrs. Justice Hill. So that explains how they worked in the circumstances of this particular case.
Yes.
So that's the scheme for control and slaughter. Next, I want to take you to the Animal Health Act and have a look at the scheme that involved in respect of compensation. Again, I won't labour on the points that James has already taken you to, but it is important to see the scheme in context. So that's behind tab 36 of the Authorities Bundle, page 1272. And it's the bottom of the page, section 31. Section 31, you'll see slaughter and certain diseases. This is the provision that says Section 3 of this Act has effect as to the slaughter of animals in relation to, and then there's the list, which includes diseases of poultry. So Section 31 tells you that Schedule 3 is dealing with slaughter. We can ignore Section 32 because we're not concerned with other diseases. Section 34 is on page 1274, and we're concerned with, again, this is the English provision, the Scottish provision follows it, so it's the provision at the top of the page that we're concerned with. And this is 34.1 was a provision that Sir James alighted on and suggested that this was something that assists his interpretation, and my submission, it points in the other direction. Because what one sees from 34.1 is the Minister may, notwithstanding anything in the Act, reserve for observation and treatment an animal liable to be slaughtered under this Act at his direction, subsequent to the payment of compensation, as in the case of actual slaughter. So what we have here is a scheme that says, on the one hand, Section 31 deals with actual slaughter and tells us that Schedule 3 deals with that. Then we have Section 34.1 that tells us where an animal is liable to be slaughtered, the animal can then instead be reserved for observation and treatment, but subject to the payment of compensation in the case of slaughter. And that must be intended to work in lockstep with Schedule 3, because that's what it tells you, that you will receive the compensation that you would have received as in the case of slaughter. And it must also be the case that the time for assessment of that must be the time that the Minister makes the decision to reserve the animal for treatment. So in the context of avian influenza, if the Secretary of State were, say, to condemn a barn full of chickens to slaughter, but reserve a sample of those for observation, say because the defendants, the Secretary of State scientists wanted to observe the progression of disease, then if the animal was diseased, and that must be diseased at the time the Minister made the decision to take the animal in for observation, no compensation. But if it was healthy, there would be an entitlement to compensation. And it can't be the case that that would change if during the course of observation the animal were to become diseased. And what this is, in my submission, is a strong contextual pointer that it's not the physical act of slaughter, but the Minister's decision either to condemn the animal to slaughter, or alternatively, despite the fact that they are liable to be slaughtered, reserve them for observation. It's that decision that creates the entitlement to compensation, and it accrues at that point.
When it says liable to be slaughtered, does that mean where the Minister has made a decision under paragraph 5.1 of Schedule 3 that they should be slaughtered, or does it mean they are in the same shed as a suspected bird, or they're a suspected bird, so that he could make that decision?
It must mean the former, because and the reason I say that is because an animal isn't liable to be slaughtered until the Minister has decided to exercise the discretion.
So liable to be slaughtered is synonymous with has been condemned.
Yes, and so you can, at that point you have a choice. Either they must be culled, or, because this provision says notwithstanding anything else in the Act, so notwithstanding Section 31 that tells you that Schedule 3 has effect, you can reserve them for... So you've got the same triggers, it's the same powers, i.e. here paragraph 5 of Schedule 3, and then you've just got another option. So it's not just culling, you can reserve for observation.
Thank you.
But the same consequences in terms of compensation.
But how does that, I don't understand, I'm sorry, it's my fault, I don't understand how this helps us construe paragraph 5 or paragraph 5.2. This is dealing with a different case. It's a case where the Minister's made a decision, i.e. has caused to be slaughtered, a group of animals, and then decides, actually I'm going to pick out a few and have a look at them. And if that's the case, then the Minister's liable to pay compensation as if they had been slaughtered.
Quite so, my lady.
But how does that help you to construe paragraph 5?
Well, the reason I say that points to what I say what I say is the correct construction of paragraph 5, is that what this has to mean, given the context it's in, is that you're not looking at what might have happened down the line if slaughter happened at some point in the future. What you look at is, at the point this is exercised, what would you have got if that animal had been slaughtered? And that must be at the time the decision is taken.
Well, it's a different provision that might lead to a different answer. The answer you give is not necessarily the answer. An issue that arises under 34.1 is the date at which you decide what, as in the case of actual slaughter, when that applies. It might be, as you say, at the date when the animal is reserved for observation. It might be another date.
I accept that, and what I say is, it would be a surprising result if you had different times. If a different policy result was intended, same result to the keeper. Animals that were the keeper's animals are being removed from their property. In one case because they're going to be slaughtered, another because they're going to be reserved. In one case, you've still got the risk that it turns out to be diseased. In the other case, actually, you get compensation as of now. This is a scheme that's intended to work as a coherent whole.
Why? This is just making provision for what happens if some animals, some birds are taken down a different path.
The reason I say that is two reasons. One is this scheme is intended to work as a coherent whole because you've got two provisions in the same part of the Act dealing with the same issue, which is what do you get if your animals are taken away from you, if I can put it that way. And I say it would be surprising if in that identical context, and from the point of view of the farmer and indeed from the Secretary of State, because there's being an expropriation of property, you would have a different result in terms of compensation. So that's the first reason I say on orthodox principles that follows. And then when we come on, and I do say this is an orthodox principle, I don't want to be suggested that it's anything unorthodox, when one looks at, as we'll come to shortly, the statutory rule of construction, the Horner principle, and I'll show you that it does apply to compensation schemes, that's particularly important because it would be unthinkable in that context when there is a very strong presumption against uncompensated takings, that you would have one rule where you don't have uncompensated takings in respect of observation for treatment, and then on Sir James construction when you have, instead of observation for treatment, just a decision to cull them all, you do have uncompensated takings. I say it's the general principle that one assumes, or one ought to infer, that the statutory scheme ought to operate consistently. And I say that applies with even more force when you're in this particular context. So that's why I say, I mean, it is one of many contextual pointers, I say. And again, I emphasise that when one is concerned with statutory interpretation, of course, the general principles are not disputed, but it is important, as the authorities say, not to have tunnel vision and ignore the context in which the scheme operates.
What I do notice is 34.3 provides that if the sum received by the Minister on the sale of the carcass exceeds the amount paid for compensation, which would suggest that it is possible, conceivable, that a carcass will have a value.
So that follows.
And that must be implicit in the structure of this, that it would be open to Minister to sell some of the animals reserved for observation and treatment. Or is this very general, so you can't apply that across the board to all the animals?
Well, no, you can, my lord. So this applies generally. So the way this works, you've got 34.2. So what 34.2 tells you is when an animal's been slaughtered.
No, I understand that, but maybe I was going too far, because it applies to all animals, including chickens, that it doesn't necessarily have the implication that I was saying.
Well, it does. So what I say that does apply generally, and what it is indicative of is a principle that the keeper should be made whole. So if what that's telling you is the Secretary of State can't get a windfall. So if for whatever reason the operation of the compensation provisions mean that you don't get...
But there isn't a general principle that there should be no uncompensated loss. There's a particular example in section 34(3) where the keeper should be made whole, but there's nothing in 5.2 that suggests that an analogous principle applies to 5.2.
Well, my lady, no, I accept that. The way you get the principle of no uncompensated loss, and again, it's because we're approaching this, it's because of the way I'm approaching it, and I apologise because I can see it has been confusing, is that one starts from the principle that when one looks at legislation, you don't assume that there is an uncompensated taking. So what you look at, and this is what Sir James has done, is he said, well, you look at that section and that must mean that an uncompensated taking was intended. And what I'm saying is, no, the opposite. So it's approaching it the other way around, is that one doesn't have to derive from this section a general principle that you will be compensated. It's rather the opposite, which is Sir James right that one finds the opposite intention, i.e. that the entitlement to compensation is negatived? And
if that's the question, I don't see how section 34 helps you at all. It's irrelevant.
It's a statute. I put it no higher than this, my lady. What it is showing you, and it is in an analogous context, and I say it is an analogous context, because in this context, you're a farmer that's had your animal taken away from you, although for observation rather than for culling, and the principle is that you'll be compensated at the value as it was then.
But that's not a floating principle. It's a principle that's anchored in the language of the provision.
I accept that entirely, my lady.
Right.
I accept that. I'm not suggesting this applies directly.
Okay.
This is purely context, and what I'm saying is it's an example. And so James said it was an example of the statutory context that pointed the other way. And what I'm saying is that that's wrong. It's an example of a coherent statutory intention that is consistent with the Horner principle that individuals...
This doesn't provide that you will be compensated. It just says you may be compensated.
You will be compensated in the same way. So
yes,
exactly. It doesn't create a freestanding right to compensation, but what it tells you is when in the schedule...
It does create a freestanding right to compensation, but it says that the compensation is to be calculated as if, contrary to the facts, the animal had actually been slaughtered.
Quite so. And the timing, and this is why it's important, and the timing is at the point that the minister takes the decision to take the animal into observation. It must be that, because
that flows from the language as well. An animal liable to be slaughtered, and then there's a reference to actual slaughter. So there's a clear distinction between the liability and the counterfactual world in which the animal had actually been slaughtered. I don't know.
If it's not helpful, it's not helpful. But what I do say is it certainly doesn't assist Sir James, which is what he was suggesting this morning. This is a pointer that actually you can infer from the terms of paragraph 5 of Schedule 3 an intention that if the animal happens to be diseased at the point of culling, no matter how distant in the future that may be, there is no compensation.
What I thought Sir James got from it, or sought to get from it, was a clear distinction drawn in 34.1 between animals actually slaughtered and those that are liable to be slaughtered, which you say means the same as condemned. And that when one comes to paragraph 5.2, it refers to the time of slaughter rather than the time when they become liable to be slaughtered. I thought that was the benefit he thought he got from it.
And what I say is that is not a distinction that one actually gets from the... I mean, it would lead to an absurd result if that was right.
Well, I'm wondering why is that absurd? I mean, I don't, for my part, find it obvious as to when you assess the payment of compensation under 34.1. Suppose you reserve a cow because it's been in the same herd as a cow subject to cattle plague, and you're observing it to see whether it does actually develop cattle plague, and it turns out it doesn't. Then you get compensation. But suppose you reserve a cow because it's been in the same herd and it does develop cattle plague. Well, we know that even diseased cattle generate a right to compensation, but it's only half as much. It's not obvious to me that you would get the £40 rather than the £20 in the latter case, because it just doesn't tell you how or when you assess the compensation. It just says if you take it for observation and treatment, you have to pay compensation. So,
As
I'm
in
not
the
sure
case
that
of actual slaughter.
I'm not sure it really, you want to say it tells you when you value the animal, whether it's, and for that purpose, assess whether it's diseased or not, namely at the point at which it's reserved. It's not obvious to me that you get that out of 34.1.
I accept that your lordship's reading of that is a tenable reading of it, and if that were right, I'd say that also points in the direction of the construction that I suggest. And the reason for that is you've got a choice. You can either order them to be culled at that point, in which case the compensation rules follow at that point, or if your lordship's right, and that is what section 34.1 means, you say, I'm just going to reserve them now, even though paragraph 1 is a good example because it was a duty to cull, so otherwise you'd be obliged to, but this is, instead of that duty, you can observe. And if it turns out that actually it's not, then you're not fixed with the obligation to pay compensation. So that again, even on your lordship's construction, would be a pointer in my favour. I say it best for Sir James, it's neutral.
Okay.
Can I ask you, just a matter of interest, does animal in 34.1 include poultry? Well, one can see that in the Scottish version it doesn't, because it means any kind of mammal except man. Do we know what it means in the English version?
Yes, animal does include. We don't have the definitional provision here. The reason, the way I can satisfy your lordship's question, I hope, is that section 31, in terms of slaughter and certain diseases, Schedule 3 of this Act has effective slaughter of animals in relation to, and then little d, diseases of poultry.
Yes, I see.
So it's a contextual indication. There is a definitional provision, you just don't have it.
Yes, okay, thank you.
Yes.
So that's section 34.1.
Yes.
Section 34.2, that we saw the property in the carcass lies with the minister. That's important when we come to A1P1, for reasons that we'll come to. And then 34.7 is a power to make regulations for various things, including prescribing for the mode of ascertainment of value of an animal slaughtered. And then to complete the picture, although I don't take anything in particular from it, but just so that your lordships, your ladyship have the picture, that the relevant order is behind tab 38 of the authorities bundle.
Sorry, the relevant order in respect of ascertainment of value.
This is the order made under 34.7.
Right.
That tells you how compensation, it deals with compensation.
Yes.
It's behind tab 7. It predates the 81 Act, which is why
tab 7.
Yeah, 38, sorry, my lord.
38.
Page 1295. So this was made under the predecessor Act. This was the reason for my sort of roundabout answer. I hope not too opaque too.
Right. So it's the provision of the 1959 order is still the relevant provisions for the person for the purposes of ascertaining compensation.
It's a successive provision, so it remains in force. Then what Regulation 3 tells you. In fact, perhaps if I ask the court to read that for themselves, please.
Yes.
So all I take from this, and I say again, it's a contextual pointer, is that whenever the value of an animal board slaughtered or liable to be slaughtered can be ascertained, then there are the various provisions.
It's terribly general. It doesn't actually tell you how the value is ascertained, other than the minister just saying what he or she says the value is.
And then there's a process of arbitration in the event of
No,
disagreement.
but is there anything that sets out how the value is to be calculated other than paragraph 5?
Not in the legislation, no. What you have are extra statutory tables that tell you how in practice that's done, but they don't have statutory force, my lord. So
Right.
there's no...
Well, there was a provision in 34 we looked at, well, we didn't look at it, 34.7. The ministers may make orders for prescribing the mode of ascertainment of the value.
That's this.
But have there been any orders made? There's been reference made to tables. I'd quite like to see a table.
I'll show you the tables, my lord.
But this is the
Are the
only
tables-
order. Sorry.
Are they made pursuant to orders?
No, they're not. They don't have any statutory force. I'll be corrected by Sir James if I'm wrong in that, but they're not. So they are extra statutory.
But the extent to which we can get any help from this phrase "slaughtered or liable to be slaughtered" depends on a range of factors. One of which includes what was the scheme under the Diseases of Animals Act 1950? Because unless we know that, we don't know.
But my lady, I don't. As I said, I don't.
No,
I'm
so
showing.
I
I'm showing
just-
this to you
I just
too.
don't see how that helps. And in any event, even if you're talking about the current scheme, slaughtered and liable to be slaughtered are both phrases that you find in section 34.
Quite,
So,
my lady, I quite accept that. I'm showing this to you so that you can see how the scheme works.
Right, okay. Are you going to take us to a table now?
I can take you to the table now. Let me get the reference for it. But the reason for showing you this is that the table isn't the be-all and end-all. If there is a dispute, it can be the subject of arbitration.
Yes.
So my lord, I'll find the reference to the tables
Okay.
as they work. My lord, I'll come back to that if I may. They were in evidence below. I'm not immediately sure where they are in the bundle. I'm moving on now to the approach to interpretation of paragraph 5. Sir James took you to the relevant general principles. I'm not going to go back to them. What is in dispute before this court, but wasn't in dispute below, is the application of the so-called Horner principle. And to orient ourselves about this, because there is a quite significant disagreement, I'm afraid to say, between myself and Sir James, can I ask the court please to turn up tab 45 of the authorities bundle at page 1497. And could I ask the court please to read
45.
1497, tab
1497. Got it.
yes, tab 45.
What's this from?
This is from Benion, the latest
Right.
edition of Benion. And can I ask the court please to read from the heading at the top of page 1497 over the page until the section headed Common Law Rights.
Yes.
So, as against that, what Sir James is saying, as I understand it, is that this perhaps overstates the position, and that the Horner principle is, in effect, a more modest one, and particularly modest when one is concerned with the interpretation of the operational minutiae of statutory compensation schemes, rather than the issue of just whether there's an authorised taking. And with respect, that is a bad point. And it's a bad point, I say, for reasons of principle, and because it's contrary to, as I will show you, over a century of settled authority. And I'm not going to take the court to all of the authority that we set out in our skeleton argument in support of this, but I am going to take the court, if I may, to three key authorities. The first is that behind tab 4 of the authorities bundle, at page 116. And what one can see if the court looks over the page to 117 is there are two columns, and they set out the statutory provisions that are an issue here. You don't have to read them. What you see is that there is a general right in section 58.1, that's at the very top of the left-hand column.
Yes.
And then 2, there's a qualification to that right. So you have a right and a restriction. That, I say, is analogous to what we have in Schedule 3, paragraph 5, a right to compensation save for in respect of diseased poultry. So the question is, well, how do you construe the width of that restriction? And on Sir James' case, as I understand it, this is not a Horner case. Because one's concerned, you've got the scheme, you just read those words and you don't need to trouble yourself with Horner. But can I ask the court, please, to turn to page 148 and read the passage. It's in the second half of the page, beginning with "in connection with this and."
Yes.
Just read that paragraph to the bottom of the page, please.
I'm so sorry, this is page 148, but
Sorry, and it's
the number at the bottom of the page.
Yes, 148, the number at the bottom of the page, which should also be the, yes.
In connection with this.
So the author, it's page 375 of the report, my lady.
Yeah, okay.
It's about 2/3 of the way down.
It's about 2/3 of the way down.
Yes. Read to where? Sorry.
Just read to the end of the page, please, my lord.
Thank you.
Yes.
So what you have here is a statement of the principle as of 1920. I'm showing you this because I want to make the point. This is a venerable proposition that applies in particular in this context where you're construing restrictions to compensation.
Well, this is a provision that provides for compensation, and then the question is the interpretation of those parts of the provisions which create exceptions.
Quite so, my lord. And I say that's analogous to what we have here, because the minister shall, save in respect of diseased poultry, pay compensation. And we have an issue here about what are diseased poultry.
I see.
So this is on all fours with this, and I'll come on to show you other authorities, House of Lords and Privy Council level, where this has consistently been applied ever since. So it's not just, as Sir James says, the De Keyser situation. Do we have a taking without compensation or not? Even where Parliament has set out a scheme, as we'll come on to see, even where Parliament set out a very detailed scheme, the principle applies so that you construe the exceptions very narrowly. So
it
this
doesn't say construe it very narrowly. It says must not be deemed to take away, blah, 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 unless it appears by express words or plain implication.
my lady is quite right. And so that
Unless one is obliged so to construe.
My lady is quite right. This is the starting point. I'm going to take the court on to show you the more recent, more authoritative statements of this proposition.
Right.
So can I ask you then, please, to turn to the decision behind tab 11, page 393. Sorry, it's page 392, I'm sorry. So this is a decision of the Judicial Committee of the Privy Council. The court will see from the head note that this was also a compulsory acquisition case, and it was also to do with the construction of a provision dealing with how compensation was to be reckoned. And there is a single judgment of the board delivered by Lord Wilberforce. And can I ask the court, please, to turn to page 399? That's 399 of the bundle,
Yes.
1621 of the report.
Yes.
And can I ask the court, please, to read the statement of principle from just next to H to the bottom of the page.
Yeah, but this is... In view of the difficulty of reaching a certain conclusion on the legislative formula, such obscurity as there is ought to be resolved in favour of the person, blah, blah, blah. So this is a case in which the provision was not, the construction of the provision was not at first sight obvious.
I agree, my lady,
So how can this approach apply if the position is as Sir James it submits, that the construction is clear and unambiguous?
If I haven't persuaded you that my construction is not a reasonable one, then I won't win on orthodox principles of construction. I don't suggest that this is as strong a legislative tool of construction as the Section 3 Human Rights Act tool.
Okay.
It has to be a reasonably open construction. I accept that.
Okay.
But what it tells you, and I put it no higher than this, and this is what your lordship will take, your ladyship will take from Bennion, is that if there's reasonable doubt as to the construction, then the effect of the presumption is that, well, Parliament must be intended to have opted for the solution that will result in compensation rather than the other one. That's as high as it goes. But
that's just another way of putting. The language has got to be clear, because if the language isn't clear, then you're in a different position. So I'm not quite clear what this I don't really understand what this adds to. The language has got to be clear.
If your ladyship if your ladyship's question is clear as in the principle of legality, one doesn't override rights, here property rights, without clear language, then I agree with your ladyship. There isn't anything between us. What I'm going to these cases to show is, because Sir James was denying the application of even the principle in the case of compensation schemes. I think what Sir James was saying is when one's construing compensation schemes, there's no room for the principle to apply. And what I say is that's quite wrong.
So you're answering that submission?
I'm answering that submission. Okay. Be clear, I accept on Sir James's appeal, I have to satisfy you that this is my construction is one that's reasonably open. Different position in respect of the Human Rights Act because of Section 3.
Okay.
Come on to that shortly. And then the last authority, which I don't need to take you to in light of that, because it may be that we're on the same page, is the most recent restatement of the principle from Mr. Justice Holgate, as he then was. It's behind tab 19. I will ask you to turn it up, because I think it's probably best to show the most recent statement.
Yes.
Behind tab 19 of the authorities bundle at page 719. And
Yes.
again, you'll see from the headnote, the second half of H2, what this is concerned with. It's again that situation where you have a detailed scheme about the reckoning of compensation, and there's some ambiguity, or at least debate, about what the qualifications or restrictions on that right are. So it's precisely the situation that Sir James was saying, that the principle doesn't bite. And if one turns on to page 732, the court will see.
Yes.
The court will see under. In fact, actually, if your lordship goes to the previous page, your ladyship go to the previous page, you'll see the statutory provisions themselves are set out at 43 and 44. So that's what you're dealing with. Again, a general rule and a qualification. And then the statement of principle, what the judge does, starting on page 733, is set out the general principles about which we don't need to concern ourselves because they're agreed. But if the court turns to paragraph 54, can I ask the court please to read 54, 55 and 56?
Starts with saying at 52 there is ambiguity in section 14.
Yes,
D.
I agree.
So that's the context.
The context is this is as I accept, there has to be ambiguity.
Yes.
So that's what I say about the Horner principle. I say it does apply, and what that means is that when one's approaching this provision, one is asking not just did Parliament intend to authorise in general the taking without compensation, but when one is considering constituent parts, i.e. was Parliament intending there to be an absence of compensation for animals that died in that period between condemnation and culling, one applies the same presumption. One asks, has Parliament clearly provided that there will be no compensation in that period? And that's as high as I put it. So that's all I wanted to say about the principles. I very shortly will just draw the threads together because I've already, I think, made my key submissions here. My case on the timing of entitlement compensation can be boiled down to three propositions. The first is that poultry, when poultry other than those falling within the definition of diseased poultry are condemned, i.e. all poultry that are not diseased at the point of condemnation, there's an obligation to pay compensation. Sorry, that's me. That's me eliding the first and the second proposition. Second is this obligation arises at the point of condemnation. Third, the issue then becomes one of valuation. And the court's seen what provision there is about valuation. I am informed that the poultry valuation tables are not in evidence.
Oh, right.
They were below, but they're not. They're not within the cohort of documents that made it over into the supplementary bundles. There is. They're published online, so what I can do, if it might be helpful, is send an email to your clerk's copy to my learned friend so that you can see what they are and what they provide.
Yes.
That might be the most helpful way to do it. And in the instant case, I say the process didn't operate lawfully because what the Secretary of State did was look at it in reverse order. And said effectively, well, what I'm doing is I'm exercising a much broader power to cull any poultry, and the consequence is it's only those that by happenstance happen to be healthy at the point of culling which are compensatable. And that, in my submission, is not consistent with the correct construction of paragraph 5 of Schedule 3. Now, the court's heard me why I say that's so unorthodox principles of construction, but I say even if it is, even if there is doubt about that, one finds that the Horner line of authority tells you what the answer is in terms of which construction is to be preferred. In terms of the purpose of the statute and parliamentary intention, what I say to that is, your ladyship will find that in my skeleton argument, and I'm not going to repeat it at length because there's only a limited amount of help you can get from it. That it is to first of all to encourage reporting of avian influenza and other diseases. That's one statutory purpose, and that's common ground. And that, in my submission, is encouraged or furthered by a construction that means that farmers, keepers, are not going to be disadvantaged because while they might have a number of very healthy animals, they might suspect influenza and they're not notified. Of course, that farmers in practice will not do that, not least because there is now an obligation on them to notify the authorities. But this is a scheme that's intended to operate with both a carrot and a stick. The carrot is, the quicker you notify, the quicker the assessment will get made and the more compensation you will get. And the stick is, if you don't, there will be the criminal consequences that follow from not notifying. So it's a scheme that, again, is intended to work in concert. The rest of I've taken you through, I hope, in the course of my submissions, the various contextual indicia. I'm not going to labour those points any further.
I asked, you were going to deal with paragraph 1.4 of Schedule 3 that specifically draws a distinct, contains specific provisions dealing with when you value. And one is compensation immediately before affected, and the other is a value immediately before slaughtered. And so that distinction is drawn there, and this is relied on by the appellant. And that distinction does not expressly appear in 5.
Yes, what I say to that again, and we're all operating without assistance as to why these particular distinctions were drawn between different diseases. But what I say is one looks at what is common to the structure of those provisions, and it is, again, as I say, what the court is doing is identifying particular cohorts and then consequences that follow from being a member of that cohort. And so the question that the valuation point, the accrual point and the valuation point are different in respect of the paragraph 1 situation to the paragraph 5 situation. And I accept that, but that is a different issue to the one about when the accrual of the entitlement to compensation arises.
Right.
And that's all the assistance I can offer about that. As to the reason for the difference in valuation timing, that is a point of policy that was fixed, one must assume, at the time of the Act or whenever the schedule was last amended.
And what do you say, Mr. Moylan, about the point I asked Sir James about, which is how do we get from paragraph 5 the idea that it's telling us when the right to compensation accrues, rather than telling us what you get compensated for and how that compensation is calculated?
So this was the point I was trying to answer. There's not part of the problem, and being frank about this, is that the scheme is not as complete as it perhaps ought to be. but I've told you what the answer is as it appears on the face of the legislation, which is there is an entitlement to compensation. We're here talking about when you get that, but your ladyship's question is about, well, when you've figured out what it is you're getting compensated for, how do you figure it out? And the answer such that it is in the 1959 order that I showed you.
No, that's not the point of my question. I'm sorry if it wasn't clear. What I put to James and what I'm asking you about isn't paragraph 5 all about identifying what you get compensated for, and 2, how much the compensation is? What is there in paragraph 5 that tells us that it's about the date at which your right to compensation accrues?
I understand your ladyship's question. I'm sorry, that was my fault.
No, I didn't put it clearly. It's my fault.
The answer is what the paragraph's doing, what all of the paragraphs are doing. And this comes back to section 31. Because section 31 tells you that those provisions they're the ones that are relating to slaughter. So you've got a schedule that is telling you about when. This is its primary purpose, is it's conferring on ministers a power to slaughter animals. Now, but for that section, but for the schedule, the minister wouldn't have any power to slaughter animals. So that's why the distinctions, and this is why I say it does tell you about when, is because the when is answered by that. That's the purpose of the provision. And that power is exercised at the point the minister decides to cull the animals. That's where I get the timing from. Because until the minister has made the decision to cause the animals to be culled, the keeper's property rights are intact. So your ladyship's right that the provision then goes on to make provision for valuation, but that's very much a secondary purpose of all of the provisions in Schedule 3. It's primarily conferring a power to authorise culls. And when one understands the Horner principle in the background, which the draftsperson would have had well in mind, the next question is, okay, you've conferred a power to cull, that's an expropriation power, what about compensation? And that's why I say that the compensation power follows from, the compensation obligation is the correlative of the statutory discretion to cull.
Right.
This isn't, to put it another way, this isn't a provision that's conferring some ex gratia right of compensation. It's a quid pro quo. It's compensation for the taking that's authorised by the first provision. And I say, if it were the other way around, if it were intended to be, as my lady put it, you wouldn't have it framed the way you did. You would have a general discretion to cull, and then very specific categorisation rules about compensation, but you don't. It's the other way around. So that is all I wanted to say about, in response to Sir James' appeal. I do say that Mrs. Justice Hill's decision was right for the reasons she gave. Unless I can assist you further on that, I'll turn to my cross appeal.
Yes.
Now, my overall submission here is that the Secretary of State's proposed construction would result in a breach of Article 1, Protocol 1, including in the circumstances of this case, such that paragraph 5 must be interpreted so to provide compensation for non-diseased birds at the point of condemnation. And here, my submission is that Mrs. Justice Hill misdirected herself as to how the assessment fell to be conducted. First, by concluding that the exercise of the power of slaughter didn't amount to a deprivation of the keeper's property in the animals. And to see the materiality of this error, one needs to go no further than paragraph 113 of the judgment, where the judge said, had, contrary to her conclusion, the condemnation properly to be construed as a deprivation, then it would be disproportionate. So if the error of law is made out, if I'm right that properly this ought to be categorised as a deprivation, then on the judge's own findings, there would be a breach of A1P1. That's the first error. And the second error is that even if I'm wrong about that, and Sir James is right, and this is properly to be categorised as a control, the judge erred in the approach that she took to the assessment of the fair balance exercise. And the reason for that is that, as one sees from paragraph 118 of the judgment, the judge thought that the relevant question was whether the Secretary of State's assessment was manifestly without reasonable foundation. So I say that's wrong. And I say that if I'm right about either of those, then it must be for this court to consider the matter afresh. They're the two errors of principle that I've identified. So the first, what is a deprivation? Can I ask the court, please, because this is the quickest way of dealing with the state of the art in Strasbourg, is by reference to the court's guide, which it produces. The guide itself obviously isn't a source of law, but it's a summary of the leading cases. So your lordship will find it at tab 45 of the authorities bundle at page 1502. And
45.
Tab
Right at the back.
right at the back.
Oh. Okay, got it. Yes.
1502.
I think it's 46, actually.
It's 40. Yeah, it's 40.
Oh, I apologise.
Don't worry. 31st of August 20.
That's the one.
Right.
And can I ask you please to read paragraph, first of all, paragraph 84, and then paragraph 96 over the page.
84 and 96.
84 and 96. So the approach is one that's familiar to the Strasbourg court, that one looks at the substance and not the form.
I think we should also look at what they say about control of use.
My Lord, quite.
103.
Yes, my Lord, quite. I was going to come on to that. But
Right,
that,
it helps just to get
yes, please do,
context.
please do.
And they do say somewhere, don't they, these are not substitutes for the cases themselves.
No, quite so. So, perhaps if all members of the court could read paragraph 103, if you haven't already, you may well have done, because the Secretary of State refers to it in his skeleton.
Yes.
Yes, so there are a category of cases where, despite the fact that something will look very much like a deprivation, the Strasbourg court might still look at it and say, well, actually, that's a control. And the classic case that provides the principle is the Agosi case, which you see referred to in that paragraph, which Sir James referred to. And the punchline of that case is that if you have property in a large number of Krugerrands, and there is a control on it that says you can't bring those Krugerrands into the United Kingdom, don't be surprised if the court will categorise that as a control on your property in the Krugerrands rather than a deprivation of it. The deprivation is the consequence that follows from you violating the control. Because that was a case that was concerned with the customs requirements on importation, which were well known. That is a world away from this case. Now, what Mrs. Justice Hill did, and I have to deal with this, not least because it's dealt with in this paragraph, is say, well, actually, there are two chamber-level cases from the Strasbourg court that deal with this principle in this particular context about the destruction or the confiscation of animals for disease control purposes. And what she isolated was a rule that said that all of these cases, by definition, are controls rather than deprivations.
When you say chamber level, my understanding is the European Court of Human Rights sometimes sits as a chamber of 7 judges or something, and then you have a right to refer, if you don't like it, to the Grand Chamber,
yes,
which is everybody. What is the domestic requirement under the Human Rights Act to have regard to chamber-level decisions?
Let me deal with that directly, and let me take you to tab 14 in the authorities bundle, please, at page 471.
Thank you.
And it's paragraph 48.
Sorry, paragraph
48, judgment of Lord Neuberger. I ask the court to read that, please. That's the answer.
Sorry, to say it again. Paragraph
48, Mum.
Thank you.
of
Paragraph 48. It's the judgment. It's the speech of Lord Neuberger.
479 is not
479. Thank you.
479.
Is not
471. 471, my lord.
471.
Well, isn't the starting point the provision in the Human Rights Act that tells courts they've got to have regard to decisions of the Strasbourg Court?
Quite so. And what this is telling you is what that means. This is what Lord Neuberger is addressing there.
Well, the decision of the Strasbourg Court is the decision of the court. And the chamber's a court. I mean, it's
exactly so. Well, what this is telling you is under Section 2 of the Human Rights Act.
Yes.
As my Lady Justice Laing notes, the obligation is the courts must take into account Strasbourg case law.
And that includes chamber-level decisions?
It absolutely does.
Yes.
It absolutely does.
Thank you. I think that was my question.
It does. No. So the reason I point out that there are two chamber-level decisions from a decade apart is that when one looks at what Lord Neuberger is addressing, which is what does it mean to take into account?
Yes.
You don't follow each and every chamber decision just because it's a chamber decision. You need to look to see whether there is a clear and constant line of decisions, and investigate whether that reasoning overlooks or misunderstands some argument or point of principle.
Well, wait a minute. What he's referring to there is he's addressing one element, is whether there is or isn't a clear and consistent line of decision. He's not saying, on the other hand, I mean, maybe this is irrelevant, if there isn't, you don't follow it.
No.
So,
it's simply the point is this: Mrs. Justice Hill concluded that there was clear and constant line of authority from these two.
I see.
These two decisions.
So you're challenging that element of her decision.
I am.
Right.
Is it also part of your submission that although Section 2 requires us to take into account, I think is the statutory language, although we don't have it, judging by what Lord Nugee says, European Court decisions, including those of the chambers rather than the Grand Chamber, less weight is to be given to a couple of chamber decisions than to 27 Grand Chamber decisions.
Quite simple. Or even one. I mean, the point of the Grand Chamber decision is you then have certainty as to what the principles are. That's the purpose of them. But even with the Grand Chamber decision, I think your Lordship's quite right. Section 2 doesn't say you're bound by it.
And Lord Newberger makes it clear that you might not be.
Exactly.
Yes.
Exactly so.
I see.
Exactly.
Thank you.
And so what I am going to go on to say, the reason I took that point was to answer my Lord Justice Nugee's question front on. What I'm going to say is that these two decisions don't provide a clear and constant line of authority for the proposition that Sir James says they do, i.e. that whenever you've got a scheme about control of animals for disease control purposes, that's a control, not a deprivation. You need to look at what the cases say. You need to look at each individual case and come to a conclusion. It may well be. So if you had a case where you were talking about the import of animals from outside the jurisdiction, and if you imported an animal that was diseased and it was then taken off you, well then you'd be in a GOSI territory. Because the control is don't import animals that are subject to, that are the diseased, otherwise they'll be destroyed. Whereas here, we're not in that territory. And what the question you need to ask is the question that one saw in the passage from the court guide, which is the very substance of the individual's right exhausted? And in a GOSI, the answer was no. You could do whatever you wanted with your Krugerrands, just don't bring them into the UK. And the court must look behind the appearances and investigate the realities of the circumstances complained of. And again, in a GOSI, you can see why the court thought it was entirely artificial for someone that had imported Krugerrands into the United Kingdom in breach of a prohibition, coming and saying, well, I've been deprived of them. Rather than just there being some control of my exercise of those and that property. But we're not in that territory. And to make that good, what I want to take the court to is the first of those cases about animals.
Right.
The one that's cited in the guidance, the Biodad-N case.
I thought that was the second one.
It's the second one in time. So I'll come on to the first one in time later. The reason I do it in that order is, as we'll come to see, the first one doesn't actually tell us anything in terms of reasoning. It's just conclusory. But I say Biodad-N is important in terms of the principle. Now, what we have in the bundle is a machine translation into English. That's at tab 33. The authentic French appears behind tab 32. There is no issue between my learned friend and I about the accuracy of the machine translation.
Sorry, can you tell me the tab again?
It's tab 33.
Thank you.
Is the English machine translation, and 32 is the authentic French.
Right.
If one turns to page 1223, the facts are important because this is one of the two cases. So could I ask the court please to read paragraphs 7 to 16?
Yes.
And then what one sees at 17 is that compensation was refused. You see this at the foot of the page because offences have been committed. So you have a scheme in domestic law that says compensation even in respect of infected animals. We'll see that that's clear from paragraph 52 a little bit later. But in this case, no compensation because of offences. So if we turn then over to page 1224, you'll see at paragraph 21 that there is a challenge before the domestic courts. That's dismissed. And then importantly, this is an important part of the reasoning, with regard to Article 1 of Protocol, this is in the middle of paragraph 21. With regard to Article 1 of Protocol 1, the Court of First Instance found there was no question of deprivation, since the cattle remained the property of the applicant who could sell them at the price of butchery, and there was therefore no violation of the provision invoked. And then they went on in the alternative. So that was then confirmed, as you'll see in the subsequent paragraphs, by the domestic appeal courts, and then it reaches Strasbourg. And the applicant maintained before the Strasbourg court that this was a deprivation, not a control. And if the court looks at page 1230, paragraph 41, you'll see the government's response to that. I ask you to read that, please.
Yes.
And then can we turn please to paragraph 48, which is on page 1232 at the top of the page. And you see what the court makes of that. Can I ask you to read paragraph 48, please? So what you see is there's reference to the Sagnon case that we'll come on to in a minute. And the court doesn't say, yeah, absolutely right, we agree with every aspect of the reasoning of that case. They just say that there's no reason for us to look again at that or conclude otherwise, because the cattle remained the property of the applicant, who could sell them and receive the butchery value. So the property in the animal remained after slaughter. So it's a control. And let's have a look then at the
Yes.
Sagnon case. That is at tab 31. Again, we've got the English machine translation at 31 with the authentic French at 30. And the analysis, such that it is on this point, is at paragraph 36, which is at page 1192. Can I ask the court to read that, please? So,
What were the provisions in that case?
so the provisions,
domestic provisions.
the provisions in that case, so that I accept the provisions in that case were that the animal, it didn't remain the property.
And where do we get that from?
We get that from apologise, my lord. Below this was a proposition the Secretary of State advanced, and we accepted it. So I satisfied myself it was the case at one point. Now I can't put my finger on it. It might be. No. My lord, it's on page 1189.
Yes.
It's in the middle of the page, Article 2. All animals of the bovine, ovine, caprine, porcine, or other ungulate species are euthanized and destroyed, whatever their origin, and so they're destroyed.
Right. So they're deprived of.
So this is a case. This is a case like our case. So I accept in this case. This is why. Sir James's argument, as I understand it, is you get biodud N that we saw, and there we see that the property was maintained, and the court thought that was important. And they say, well, Sir James says, well, if you add that to this, where you had the same situation as we have here, and this was analysed as a control, you can spell out a clear and consistent line of authority.
And you say no, you don't.
You can't,
because the second case simply doesn't comment on the first case, and the second case, the facts were different.
And the second case says, there's no need to revisit it, because in this case the property was retained. So you might say there was a wry judicial eye being advanced at this decision, for which there's no reasoning. So one doesn't get a clear and constant Strasbourg jurisprudence from these two decisions. What one needs to look at are the principles, and are the principles that I've taken you to, and ask, in substance, in the instant case, has the keeper been deprived of property rights in the animal, and if so, when?
It's a very broad submission to make in the light of paragraph 103 in the guide, which actually is saying that there's a constant approach to forfeiture and confiscation in a number of authorities that are referred to there, from which that proposition is derived. And the Belgium case is given as an example of the application of that approach to forfeiture and confiscation, which are generally regarded as control of use of property.
I absolutely accept that. I absolutely accept that. And the paradigm example of that category of cases is, as Sir James said in opening, was the Agosi case. And one sees why that is a control. And I take the court to a recent and I hope helpful example of where the line is to be drawn, and that is the Activa case, which the court will find behind tab 35.
35.
Tab 35, page 1250. So what one sees here, paragraph 1, you see what the case concerns. Seizure of goods imported legally, but were allegedly traded in contravention of regulations on trade in goods and services. Then if one turns to paragraph 9, one sees what happened. A cargo of iron rods was seized, and then at paragraph 11, they are then sold by the state to the third party. So it's It's a factually similar case to those that we were looking at before, the Agosi importation case. And what I'm relying on this for, the court turns forward to paragraph 78, is the statement of principle, because there's an assessment of the relevant authorities. And can I ask the court please to read paragraph 78?
Right, leaves the question open.
And Vio Dardenne is cited in support of the first category.
It is, but the court will recall that in Bio Dardenne, property was retained. And that was what the court remarks upon in the passage I took you to. That was the distinguishing feature.
Yeah.
And what the court says is the point of departure is, does the confiscation involve a permanent transfer of ownership whereby the applicant has no realistic prospect of recovering its possessions?
I must admit, I don't read paragraph 48 of that in quite the same way as you do, or I think you do. How I read it is it's saying Chagnon applies, and further, there's no reason to decide otherwise because. It's not saying we are deciding this because, it's an additional reason it's additional reason to follow what was decided in the previous case.
Not to reconsider. Yes, I accept that.
Well, no reason to decide otherwise.
Quite so. I
say the decision doesn't appear to depend on that, is what I'm asking you.
Well,
48 says, already been considered, measure in Chagnon. We are applying that.
I accept that, my lord. And so this is why it's important to focus on what you're looking for here. And that is this a clear and constant statement of authority from the Strasbourg court to the effect that in this particular context, irrespective of whether you retain any property whatsoever, it's a control and not a deprivation. And I say it doesn't. I accept what your lordship says. That is exactly what they say. They say we're not going to reconsider that here because it doesn't arise on these facts. There'd be no reason to depart from it because you retain property in it. So clearly it's a control. What it's not saying is we're endorsing that reasoning or this authority is any additional weight for the proposition that even if the position were otherwise, it would be a control. And so what one doesn't get from that is a clear and constant statement. What you've got is one Strasbourg decision, Chagnon, which is now 14 years old, where there is no reasoning at all in support of the proposition that it was a control and not a deprivation in that case. And then you have a separate decision, a decade later, that references it and then says, well, that was correctly decided. It says, well, we're not going to reassess that here because you did retain property. So if the question is, do you spell out from those two authorities a clear and constant line of Strasbourg authority to the effect that this is a control, not a deprivation? The answer in my submission is no.
And where do you say the judge says that?
You mean Mrs. Justice Hill?
Yes.
Yes. It's...
Seven and
107, I'm being hopefully reminded by my learned friend. It's 108, my lord.
Yes, and 108 she says that they are consistent with each other and are consistent with the general constant approach of the court generally to forfeiture and confiscation. She's not saying that those two decisions on their own are a consistent, whatever the phraseology is, line of authority. She's referring to the other authorities identified in 101, 102, 103 of her judgment, isn't she?
If she is, then that in my submission is an error as well, because I say that the general proposition that follows from the Strasbourg authorities is that I showed you in the Activa case. The distinguishing point is whether there has been a permanent transfer of ownership where the applicant has no realistic possibility of recovering its possessions. And it's certainly distinguishable from the Agosi line of authority that my learned friend relies upon, because there the scheme of control is obvious, because you're outside the jurisdiction, you have property in Krugerrands, the control is don't bring them into the United Kingdom or there'll be a consequence. They'll be taken off you. Whereas here, you're in the United Kingdom, you've got the chickens, and then the Secretary of State has imposed a regime whereby, in the public interest, and there's no dispute that this pursues a legitimate aim of disease control, there's no dispute that it's in accordance with law, but what Parliament has done is said, you chicken farmers are going to be subject to these very broad, very sweeping restrictions on suspicion.
Sorry, I don't understand.
I've been called this.
I'm sure that was an accident.
Not personally directed.
We'll take that in the spirit, actually. It's not intended. But this is a general measure that is being inflicted on these farmers for the interests of the community as a whole, i.e. disease prevention in the community at large. And what the authorities tell you is when you have a deprivation, and this is classic A1P1 territory, in the general in the general public interest, you have to give compensation. If it's a deprivation, you have to give compensation, and that is what follows. I'm mindful of the time, and I'm also mindful of the need to give Sir James time to reply.
Right. So your proposition is this is a deprivation based on the authorities you have showed us, that there isn't a clear and consistent line of Strasbourg authority to the opposite effect. But then you're saying that when there is a deprivation, as I've written it, you have to give compensation.
Yes. And let me deal with that, because my learned friend's submission is I understand it is actually, even if you're in the realm of deprivation, it could still be okay here, because you don't have to have compensation. And that was not a proposition that the judge accepted below. You have the judge's findings on that, and I do rely on and endorse that, including by reference to the authorities she cites, because the authority that my learned friend relies on was in the very different context of the fallout of the Northern Rock dispute. And then there's an analysis, and you'll find this in my skeleton, you'll find it in the judgment, of the authorities there. And it's true that there are exceptional cases where you might depart from the requirement to pay compensation without there being a breach. But on the court's analysis, there were two ever, and the judge below found that there weren't any. There was no case that was put about exceptional circumstances below. Sir James hasn't put a case about exceptional circumstances here. So I say, if we are in deprivation territory, the judge was precisely right to conclude that that means it's without more disproportionate.
When you've taken us to the guide deals with compensation from paragraph 175 onwards, and it's in the section dealing with fair balance, and saying compensation is an element of fair balance. You wouldn't dispute that.
My lord, can I take the court back a step?
Yes.
So your lordship is absolutely right. If you're in control of use territory, and we get into the fair balance, this is my alternative submission. We'll get onto that in a minute. But can I ask the court to read paragraph 100? This is back in the guide at page 1507 of the bundle.
Yes.
And can I ask you please to read paragraphs 176 to 179?
Yes. 176 to 179.
Yes, please.
Yep. Right.
So you've got the general rule, which is compensation required. There is a recognition that there may exceptionally be cases where it isn't. But if we turn up the judgment, can I ask your lordship, please, and your ladyship, please, to turn that up?
What they say in 177 is what is reasonable will depend on the circumstances, wide margin, etc. While it's true that in many cases of lawful expropriation only full compensation will be regarded, but it depends. So,
Yeah.
not surprisingly, they say, okay, anyway, where in the judgment?
So, sorry, my lord, so let me deal with that first. So, what we have here is a scheme that Sir James said, in respect of many of these barns, where all of the animals were killed, but were diseased by the time they were killed, no compensation. And actually, if we delayed a couple of days, no compensation at all. So we are in no compensation territory. That is what Sir James must say the effect of the act is, in respect of animals that were healthy at the time that they were taken off the onus. The owner, at the point of condemnation, just we're outside.
They weren't taken off the owner.
The owner can't.
They were controlled, and they were controlled for what might be thought a very good reason, is that you can't let them go anywhere, because if they do go anywhere, you might spread the disease.
What I say to that is actually from the point of condemnation, and it's not just because of paragraph 5 of Schedule 3, it's also because of the 2006 order. They were deprived of them, because from that moment on, thinking about the test, is there any realistic prospect that the owner will recover any rights of property or can do anything whatsoever with them? And the answer is no. You can't. The only thing you can do with them from that point on is assist.
Yes.
So you've seen on the facts of this case that the restrictions were put on at the same point as the decision to cull. The only thing the owner could do was assist the Secretary of State culling those animals. Can't move them, can't sell eggs, can't sell byproducts. If any, the carcasses, when they're destroyed, will be the property of the Secretary of State. And if any of it happens to be left behind, they have to be destroyed off. So when you look at the Activa test, the point at which the owner is deprived of the property is the point at which the Secretary of State makes that decision. Because the owner can't at that point. If the Secretary of State hadn't done that, then the owner would be free to go and move chickens, put biosecurity measures in, but none of that. So the deprivation, I say, it does accrue at that point.
But what we're looking at the moment is fair balance, looking at justification, aren't we, I think? I think you have to put quite strongly into the balance the reasons for this. And the reasons are public interest.
My lord, that will always be the case when one is an A1P1 territory, because the way the analysis works is if you have a control, any type of a control, it must be in pursuant of a public interest.
I understand that. And coming back to your opening submission, you have to give compensation. And I'm just testing, have to give compensation. It's a very high-level, broad submission.
And I put it that high because that's what, and perhaps if I can take your lordship to the case that my learned friend relies on to explain why I put it that high.
Right.
That's the SRM Global Master Fund case, which was the Northern Rock case. It's behind tab 13 of the authorities bundle. And can I ask your lordship to turn it up, please, in your ladyship at page 438. Can I ask you to read paragraph 48 and the rider at the bottom of paragraph 48, please?
Paragraph 48.
48, it's page 438. And that's why I say, my lordship asked me to take you to the passage in the judgments. In the core bundle at page 120, paragraph 113. Can I ask the court to read that, please?
Sorry, which paragraph?
Sorry,
again?
paragraph 130, it's page 120.
Yes.
And this is to address my lord's point. Of course, it is accepted. There's no dispute between Sir James and I that these deprivations, controls, whatever they are, however they're properly characterised, were done in the best of intentions, according to a lawful statutory purpose. But what all of the A1P1 authorities say is that's a given. You've got to have that if you're interfering with A1P1 rights. But when you're depriving individuals of property in the general interest, because the general interest is in all of these cases, you have to compensate unless there are exceptional circumstances. And that's not what the Secretary of State set out to say. The Secretary of State set out to just say it's control and it's fair balance, and that, in my submission, is wrong. I'll come on in my alternative submission to say why, if I'm wrong about that, about categorisation, then there's still an A1P1 breach. But I say we don't get there in this case, because it's a deprivation, as the judge quite rightly found. If that is the proper legal categorisation, as I say it is, then it follows that there's been a breach of A1P1 because of the absence of compensation.
So where does that take you?
So where that would take me is in the circumstances of these individual cases. One would, even if the court wouldn't, on orthodox non-Human Rights Act principles of construction, read the provision in the way that I set out in opening, so that the compensation would be paid. And it's for the first time this morning, Sir James suggested, and it wasn't suggested below, that it simply wasn't open to the court on Human Rights Act grounds to construe it this way. If that had been the case that Sir James had made, even in his skeleton argument, we would have had authorities to show you about how broad the interpretive discretion is. If we get there and the court needs more assistance, then perhaps the court could ask for it. But the Garden-Mendoza case is a good starting point about the type of constructions that are permissible when one gets into Human Rights Act territory. And if that had been Sir James's position, pleaded position, then we probably would have amended to add a request for a declaration of incompatibility. And if we get there, I would reserve my rights to do so. But there's no statutory bar to that, because the only requirement is if the court's considering making a declaration of incompatibility, they have to put the Secretary of State on notice, and happily Sir James is here. So I see why forensically Sir James said, you can't have this, that construction's not open, because otherwise it might be said to weaken his case on ground one. But I would hope that if we reach the point where one has to search for a compatible construction, we can have a more constructive debate. But I do say that I would be entitled, if nothing else, to a declaration of incompatibility. And in that circumstance, the remedial powers of the Act would be open to the Secretary of State to do what he thought fit to remedy the incompatibility.
Can I be sure that I have understood this correctly? Is it crucial to your submissions on this point, not this point, the previous point, that full compensation is needed, that the act of deprivation is the decision to condemn? I put to Sir James floated the possibility that the birds that get diseased and die before they're culled wasn't the Secretary of State who deprived the farmer of them at all. It was the disease that killed them, not the Secretary of State.
Well, that might be on the Human Rights Act analysis. The analysis is the deprivation occurs at the time the decision is made, because that's when, as a matter of the law of property, if nothing else, the farmer can do nothing else with the animal. They're deprived of the property in the animal.
Well, I'm not sure that's strictly right as
It's a matter of
domestic law. But I don't think the property is vested in the Secretary of State
until the culling occurs. Okay, yes. I accept that, my lord. But in terms of the Strasbourg law, where you look at, is there any meaningful prospect of the farmer regaining any economic value from the bird? From the point of condemnation, the answer is no.
So at that point, this is your case. At that point, effectively, the farmer's lost his birds, and it doesn't matter for this purpose whether ultimately they're killed by the disease or killed by the gassing.
It might, and the reason why I say it might is because there will be when one comes on to valuation, we're in a slightly different territory about what the compensation would be. But it doesn't matter for the purpose of whether this is a deprivation or not. And when it comes to the Secretary of State designing the compensation scheme, then they may well be factors the Secretary of State may want to take into account. But the point is, it's at that point that it accrues. So no, I accept your Lordship's point that it doesn't matter what happens subsequently, analytically. That's the point. And again, that's consistent with the statutory scheme. Yes. Because you see that the Secretary of State can hold back and wait, and indeed, as you've heard what I've said about the structure of the provision, Secretary of State can say, well, I'm going to cull the ones that I know are diseased, but I'll just wait and see about the other ones. And then the risk remains with the farmer. But from the moment the Secretary of State pulls the trigger, that's when the consequences follow in terms of A1P1. The last point I want to make is that if I am wrong, and Mrs. Justice Hill was right, and this is a control rather than a deprivation, what the judge did was say then what the court has to go on to do is the fair balance exercise, and the court's seen from the guide what that involves. And what the judge did is say, in this case, what I'm required to do, and if your Lordship, your Ladyship still have the judgment up, you can see this from paragraph 118 of the judgment. You see what the judge said. This is, if the condemnation is a control of use, I do not consider the approach as manifestly without reasonable foundation.
Yes.
So that's the approach. So in a nutshell, if I am right and that is wrong, and I'll come to show you the Court of Appeal authority that shows you what the proper approach is, then it is for the court, this court, either itself or on remission, to make that assessment for itself, because that was, I say, an error of approach. The court ought to have done the exercise we'll come to see in the Aviva case, of making the assessment. Of course, as Sir James says, making such allowances for special institutional competence and democratic accountability, etc. But one doesn't just say, I look at manifestly without reasonable foundation and ask, is this effectively irrational? That's not the approach. And to make that good, can I take you to, please, just very quickly, the Aviva case. It's a decision of the judgment of this court. It's at tab 22 of the authorities bundle. Can we turn, please, to paragraph 77, which is on page 838. What you see there, right at the top, the test for assessing an infringement, you see it was common ground that one applies the familiar four-stage test. We haven't been troubled with that here because really there's no dispute that it's about anything other than the final stage. Then you see at paragraph 80 there was a dispute about whether and to what extent the manifestly without reasonable foundation test ought to be applied. And can I ask the court please to read paragraphs 81 to 85? And then what one sees from paragraph 97 onwards, and I don't ask the court to read that other than just to look at the general approach, is the court goes on and conducts the fair balance analysis for itself by reference to the proper, correct approach, i.e. applying such weight as is appropriate to special institutional competence, but not mechanistically on the basis that the only question for the court is whether the entire process, the scheme as a whole, was manifestly without reasonable foundation. And I say, if I'm right about that, if I'm wrong about deprivation, then in any event the judge failed to conduct the required exercise, and it's for this court to do. And I do say that even if it's not, formally speaking, a deprivation because of the application of the Agosi principle or something akin to it, we are in very different territory here because the farmers are not the smugglers in Agosi, and the absence of compensation, along with the other factors that I've set out in my skeleton, points to a finding of incompatibility absent compensation. So, my lords, my lady, unless I can assist you any further, that's all I wanted to say.
I had a question. Suppose the Secretary of State didn't have all these powers or didn't exercise these powers, and a farmer with a shed full of poultry discovers that some of them are infected. Could he realistically continue to sell healthy birds from the same shed? Or would his duty to the public mean that he'd have to, in effect, write off the whole shed anyway?
I think the answer to that question is obviously responsible farmers wouldn't do anything. Responsible farmers wouldn't do anything to put the public at risk.
That's what I suspected the answer.
But that doesn't mean that they would all die.
No.
because the Secretary, in this, the Secretary of State's own evidence that was accepted by Mrs. Justice Hill was that there's actually rather a lot that farmers can do on farms to reduce
In terms of biosecurity.
in terms of biosecurity. But that's all taken out of their hands.
Yes.
Once the Secretary of State comes along, the Secretary of State has taken over. They're calling the shots. So the answer is, I'm afraid it would depend, but it's not an answer to the issue.
The other thing is you referred not that long ago to where the risks lay, and there was reference in, I think it was section 34, to insurance. Are we concerned with whether farmers can or do get insurance
So
against this risk?
there was. So this is, in the prehistory of this claim, sorry, I'm going to give you a slightly long-winded answer because this was an issue. Because of the way the Secretary had dealt with what it represented to the industry, you actually couldn't, I'm looking backwards to make yes, you actually couldn't, at this stage, you couldn't practically get it.
Right.
So that's the answer factually, is that farmers couldn't. But of course that provision's there to make sure there's no double recovery.
Smith?
My lord, my lady, thank you.
Thank you very much. Yes, Mr. James.
My Lord, to return to the issue of interpretation, if I may first. The main interpretive thesis that my learned friend now, at least initially, advanced is that the first paragraph of paragraph 5 in the schedule to the Animal Health Act is the thing that drives everything. And as originally presented, the submission was that provision, in other words, subpara 1, required the minister to distinguish between at least diseased birds and other birds, and B, therefore, the minister could and needed to do so. And so at that point, all that you needed to make his version of 5.2 worked. That was the thesis, and so 5.1 was said to drive it, and I respectfully submit that's a hopeless submission. What sub 1 of paragraph 5 evidently does, what was described by my lady, it gives power to the Secretary of State to cause to be slaughtered poultry across the range of situations identified in A through C. That the purpose is therefore to identify the breadth of the power to cause to be slaughtered. Nothing more. There is nothing in that provision, either in terms or implicitly or to be derived from any form of reading of any of the language in that provision, to require the sort of differentiation at the point of deciding to exercise that power on which this thesis depends. And it is entirely unsurprising that the provision does not do so, because it's very, very difficult to see how that could be done. That differentiation exercise could possibly be done at that time, or indeed in the speedy time that would no doubt be needed if ultimately you were going to serve the aim of containing an outbreak. It's unsurprising also because it's entirely unclear why the Secretary of State would need so to differentiate in order to exercise the power that is given by sub 1, which can simply, on the proper reading of it, be exercised to cover any and all of the categories that are identified. And it is unsurprising, finally, because there would, I respectfully submit, be a serious risk of undermining the absolutely core and central purpose of the provision by insisting on the sort of differentiation that my learned friends seek to rely upon as a requirement of 5.1. If you were to insist on that, with all the practical difficulties, nay, impossibility of trying to distinguish at that stage between a diseased and a suspected bird, or any of the other categories as compared to those, then you run the risk of not being able to contain the outbreak, and that's the obvious and fundamental purpose of 5.1. So we respectfully submit that that reading, that interpretation necessary for the purpose of making his 5.2 argument fly, and the premise for it as originally advanced, just simply cannot work. And of course, if that falls away, if he's wrong about the interpretation of 5.1 as I submit he very plainly is, and there is no requirement to differentiate, then all of the consequences that he sought to build from that premise fall away. You cannot and will not, under the statutory scheme, know whether at that stage a bird, you're not required to know whether at that stage a bird is, for example, disease suspected or healthy. And so 5.2, when you get to it, is not necessarily or at all determined at that point. So that was my learned friend as originally presented, as the argument was originally presented, with 5.1 as the engine that drives 5.2. Then the lunch period intervened, and the last question asked before lunch was the question my lady asked. And when he came back after lunch, a different answer was given, which seemed to accept that the Secretary of State could rely upon the general power and did not need to distinguish under 5.1 at the point at which that power was exercised. And that, of course, was both a reasonable reflection and a correct outcome to that period of reflection. But the difficulty for my learned friend is that it entirely undermines the argument that 5.2 can then be said to simply flow from 5.1 and that 5.1 is the engine that drives all. So we do respectfully submit that that difference is itself significant, but we do say that having reached that position correctly, the engine for most of what followed in relation to 5.2 sputtered and rather disappeared. We also do respectfully agree with a point that my Lord Justice Nugee put, which I confess hadn't occurred to me before about 5.1, which was that 5.1 could equally well have said slaughter rather than cause to be slaughtered. And it would operate in exactly the same way. You would have to conclude that slaughter would encompass the Secretary of State directing someone else to slaughter, but there's no difficulty with that. They could be agents in the Carltona sense or otherwise for that purpose. But what that illustrates as a point, I respectfully submit, is that the provision then can't really bear the weight that my learned friend sought to put on it. Because if it would work just as well as an exercise of power in relation to subparagraph 1, if it said slaughtered or caused to be slaughtered, then you not merely lose the engine that would drive 5.2 in the sense in which you initially submitted, that the paragraph as a whole should work, but you entirely undermine the basis for seeking to imply the words that he needs to imply into 5.2. So that takes you on to 5.2 itself, and my learned friend accepted that in relation, if I call it line 1 and line 2, you know what I mean, the division between the duty and the value, but he accepted that you had to imply words into the first half. And that is problematic. I don't go back over them, but for all the reasons we gave, including that you would in fact have to imply, which itself is a pretty big interpretive thing, and also, not merely that, but you'd have to imply language or concepts that are squarely used elsewhere, not merely in the legislative scheme, but in the very paragraph that one is dealing with. So his argument on 5.2 appears to assert that the true intention of Parliament is in effect entirely hidden in 5.2, and that what it actually meant was something which it didn't say, and self-evidently could obviously have said, because the very concept he says needs to be implied is used elsewhere. So that was the first part of it. In relation to the second line, or the second half of it about the value, he initially asserted that there was no need to imply those words into what I call line 2. And the reason he was initially tempted by that submission, beware of Greeks bearing gifts, but the reason he was initially tempted into that submission was because he might get a slightly greater table value later. But he then accepted later on in the submissions that he had to imply there too. In other words, essentially the same wording, cause to be slaughtered, had to be implied into the second half of this provision as well. So Homer, in the form of the parliamentary draftsman, has nodded twice by not using the words that one sees at the very opening line of paragraph 5.1. And the difficulty for him is that even that ambivalence of position indicates the uncertainty to which his interpretation leads. And it's a little difficult, it might be thought, even in terms of the unit price and all of that, it's a little difficult to see, even on his case, why the later unit price would become irrelevant. But on his case, once you've implied the words in, you then have to go back to the earlier unit price. It's not entirely clear why that happens either. So we respectfully submit that for all of the reasons I gave in opening, his interpretation of paragraph 5.2 is simply not a proper or tenable one. The meaning of 5.2 is absolutely crystal clear. I make no submissions about the order on which my learned friend spent some time, and he correctly and helpfully accepted that a subsequent piece of subordinate legislation is irrelevant to the interpretation of primary legislation. And of course, most of the provisions of the order that he took you to were 2006. There are certain circumstances, they're very narrow and they normally depend upon a coincidence of time in which you can rely on subordinate legislation for the purpose of interpreting primary. Those were considered, just for your note, by Lord Sales in the PACAR section, the section of PACAR that I took you to earlier, and I don't go back to that. But they don't affect this point, nor do they affect the correctness of my learned friend's concession that none of the order can be relevant to this question of interpretation.
Is that limited to cases where you bring in the primary legislation and the secondary legislation at the same time as a sort of package?
Pretty much contemporaneous, so you can see that Parliament was looking at the same thing and looking at the outbreak from the primary that it passed at the same time. That's the essence of it. But that doesn't touch this point. So that's all I want to say about interpretation. So far as purpose is concerned, the purpose of the legislative scheme, purpose of 5.2, my learned friend made one point, and one point only orally. I'm sure there are others in the skeleton argument. One point orally, which was that his reading of 5.2 would be jolly helpful in promoting the purpose because it encouraged early reporting. That was the point that he made. And my short answer to that is you do not need that encouragement under the statutory scheme, and you do not need to interpret other provisions in a particular way because they might contribute to the thorough benefit of early reporting, precisely and simply for the reason that there is an express and clear duty on farmers to report, and you'll recall that was in Article 9 of the Order 1391 in the Authorities Bundle. You have to report if you suspect. So purpose, the point is a bad one.
And that's reinforced, I think, by the fact that if you don't, you commit a criminal offence. Is that right? Yes. Exactly
right, as I think we're both agreed.
Yeah.
Just briefly in
so
relation...
if you've got that stick, do you need a carrot?
Sorry?
I said if you've got that stick in the language that Mr. Burke...
If you've got that stick, you don't need the carrot, no.
Yeah.
Well, the carrot, becomes rather obsolete.
Yeah.
But my lady, yes. Horner, then, if I may, very briefly. The submission that we make about Horner, again, I don't repeat, we don't necessarily need to hang a submission on a broad proposition that whenever you're dealing with a compensation scheme, Horner can have no application. That is to overstate the submission I made. The submission I made, as you will recall, is that the Horner principle is a relative principle, particularly when one takes into account the principles underpinning of it, as identified by Lord Reid EI, Lord Reid in Westminster Bank. In other words, the more savage the provision, the less likely it is that Parliament has intended it, and therefore, and so on. So one doesn't need to, it's no answer to say, well, here's somewhere a case in which a compensation scheme was in place and the principle had some application. But perhaps the more fundamental submission is that on no view, I submit, does it get you to a place, the application of that principle, where you effectively just have to say, all I have to do is identify a tenable interpretation enough to tee up ambiguity, and that's the end of it. It is a canon of interpretation that is designed to assist the court in ascertaining the true meaning and effect, applying all of the relevant canons of interpretation that might be helpful when you're looking at a particular scheme. And the cases across the board in which it's been wheeled out and has worked for a claimant, all of those cases, it has effectively been used as a tie-break. What it doesn't do is to alter the fundamentals of the scoring system. It doesn't say you get to 15 love up and you have to concede the game. It's used as an interpretive tool or canon in circumstances where the court, having done the exercise, is really in doubt about what the provision means. You can cast that in a variety of ways. So we respectfully, as I hope I put it in opening, we urge caution with its application rather than seeking to deny the principle itself, which is, of course, as one rightly points out, it is of long-standing and acknowledged at the highest levels. So A1P1, finally, if I may, just on the approach to chamber decisions, I think we ultimately reached the right place. Section 2 of the HRA, taking account of includes both chamber and grand chamber decisions. It's not about excluding chamber decisions, but there is a strong sense from the authorities that, of course, grand chamber decisions are of particular weight and authority. There isn't, just to be clear, I'm not sure whether my Lord Justice Nugee was putting this or not, but there isn't a right on either party to go to the Grand Chamber. You have to go through a filtering process with a committee of the Grand Chamber determining whether it raises an important point of principle, effectively. So there is a bit of a kind of leave filter.
You can ask for it to be referred.
You have to ask to go there.
Yes,
and then
but
the
you
committee,
don't automatically get it.
You don't automatically get it, so just to be clear about that. And then you'll have seen references in the cases my learned friend took you to it. It's obviously closely linked with the ULA principle under the Human Rights Act, which was considered again in a Supreme Court case called AB and the Secretary of State for Justice. And what the Supreme Court did in that case was to re-look at ULA and effectively say that the English courts can take a particular position under Strasbourg authority and apply it to a new set of circumstances if they can be, and the phrase was repeated twice, so we assume deliberately, if they can be fully confident that that is where Strasbourg will go. But you see immediately the link between the ULA principle and the question of approach here, particularly in relation to lines of consistent authority. So far as consistent authority is concerned, again, there have been lots of cases in which the particular authority is not quite on point, or they're all chamber decisions and rather than grand chamber decisions, and the Supreme Court has swerved round and said this is part of the dialogue. And there have been others, e.g. prisoner voting, in which they've said, well, we may or may not agree with the principal reason that Strasbourg Court has got to, but we've now asked them 2 or 3 times and the Grand Chamber keeps coming back with the same answer. So there are variations and degrees that are in play there. So far as our context is concerned, we respectfully submit that the judge's analysis was self-evidently the correct one. That she placed the 2 authorities to do with culling within the context of a broader body of case law, which was the one that was referred to, I think, in the court's guidance, but the broader body of case law, which I identified earlier on, which effectively say you can have an element of a control of use scheme that on its face looks like it involves a deprivation. and that fact doesn't necessarily stop it being a control of use. Agossi is the start authority in that, and still a pretty important authority. Our learned friend said in relation to Agossi, well, don't worry about Agossi, because Agossi was plainly a control of use, because you couldn't bring the coins into the United Kingdom, and true it is, you couldn't bring the coins into the United Kingdom. But the relevant part of Agossi was not the bringing of the coins in, it was what happened when you did so, and you forfeited them. So you lost all rights to the gold coins at that point. And if that aspect wasn't a deprivation, it's hard to see what was, but it didn't matter.
Well, they said it, in one sense, it plainly is a deprivation.
Yeah.
But it's still, for the purposes of
Exactly.
A1P1, it goes into the second paragraph.
Exactly, and that's the point. But the reason, no doubt, the judge went to the my Lord Justice Moylan was plainly right to draw attention to the phraseology she actually used about consistency in the judgments. One needs to be a little careful about that. But so far as that is concerned, one can see why she was interested in those two authorities, because those two authorities are actually about our facts, or equivalent. They are culling authorities, and in both of them it was held to be control of use, even though there was culling. And we respectfully agree with my Lord Justice Moylan's analysis of what was actually going on in paragraph 48 of the later case, which is the B.O.R. Dardenne case. I confess, when I read that paragraph, I read it on, as respectfully you did as well, which is to say, here's Chagnon, we agree with Chagnon, and by the way, there's no reason to start going anywhere in relation to Chagnon doing anything to call that into question, not least because the facts of this case are a fortiori, because they retain some property rights. But I respectfully submit that having those two cases specifically about culling it is important and was properly taken into account by the learned judge. So that's A, control of use or deprivation. B is what happens in relation to deprivation if it is a deprivation. And the position that we take in relation to that, respectfully, is that the guide that you've now been taken to on a number of occasions accurately sets out the correct position in principle. Even if it's deprivation, compensation is not the mandatory or necessary consequence. One could have a debate if you needed to about exceptionality or otherwise, but it doesn't automatically follow. And in any event, which was the other reason I said one doesn't need perhaps to exercise too much about this, here there is a scheme of compensation. And of course, if you actually have a scheme of compensation, what the Strasbourg court then does is to examine that scheme. It doesn't castigate you even in the non-exceptional case and say there's therefore a breach. It looks at whether the scheme itself strikes a fair balance. That's the nature of all the analysis in all of those English cases. The property realignment case that was James and Lithgow and all of that, they were all about examining the ingredients of the compensation scheme that was provided. And that takes one into the third and final area, my C, which is fair balance, however you get there. And the particular criticism of the judge's judgment that is made by my learned friend is that the phrase manifestly without reasonable foundation was used, and that was the test that was applied. And I respectfully submit that she was perfectly entitled to go to that concept. It is a concept that has been regularly used by the Grand Chamber in the Strasbourg Authority. I won't go back to them, but James, paragraph 46, tab 27, Lithgow, which was the case cited by the judge after the reference to manifestly ill-founded, paragraph 122 of Lithgow used that phrase, manifestly without reasonable foundation again, in relation to the judgments made about a compensation scheme for shipbuilding nationalisation in that case. That's tab 28, and that was Grand Chamber. And that is the case that is referred to in the ECHR's guide, the European Court Guide. I think you were taken to the relevant page. The paragraph that referred to manifestly without reasonable foundation cited Lithgow, under A1P1 for that concept being in use. There, it's paragraph 178 of the ECHR guide, tab 46, page 1507. And one also sees that concept being used and applied by the Court of Appeal in the Northern Rock nationalisation case, SRM. And again, I don't take you to that authority, but you will see from the paragraphs I'm about to give you that it also used the concept of manifestly without reasonable foundation, but repeatedly and in the application of the principled approach to the facts of Northern Rock. That is in Authorities Bundle tab 13 at page 420, and see if I can just give you the paragraphs for present purposes. Holding number 8, paragraph 53, and then paragraphs 75 to 77. My learned friend entirely fairly referred you to the Aviva case, tab 22, and the Aviva case was an analysis, or involved an analysis post the case I referred to, an opening of SC, Lord Reed, EE, doing the what does manifestly without reasonable foundation mean? And the answer is it means wide margin of appreciation, but the features which go to determine the particular breadth may vary according to context. And that is the wisdom one gets from SC, and that is the wisdom that is repeated by Lord Justice Dingemans in the judgment in Aviva. But there's no difficulty, therefore, with the use of the phrase. The use of the phrase has been constant and frequent, and it wasn't disavowed as a phrase even in SC. It was used and applied by the Supreme Court, Lord Toulson in DA, an earlier case. So there's nothing wrong with the phrase. What the phrase does, however, is to illustrate the breadth of the margin. And we respectfully submit that there's no reason to castigate the judge for having used the phrase. She correctly relied on Grand Chamber authority, the correct European Court approach. If there's a criticism, it's that in some way, shape or form, she didn't apply it properly, but that isn't the criticism that is made. The criticism of principle is that she relied incorrectly on the very concept of manifestly without reasonable foundation. And we respectfully submit that that can't fly as a submission for the reasons I've given.
I suspect this is too late at the end of the day to raise what may be quite a large question, but is there a difference between the application of the manifestly without reasonable foundation test when the Strasbourg court is looking at what the state has done, and when the domestic court is looking at what the legislature has done?
The short answer to that is no, there isn't a difference. There was quite a lot of early debate under the Human Rights Act, as you will recall, which may be what's triggering the question. There was quite a lot of early debate about whether margin applied in a different sense, and the way in which that case law ultimately resolved itself was to say, yes, one recognises the difference because they're looking at national authorities and they're an international court, but the basic conceptual idea of it is very similar. In other words, that there are certain circumstances where you accord primacy of decision making to a particular body, in Strasbourg, the national authorities, and that then led our courts to say that the reflection of that under our domestic arrangements is all the variable degrees of respect that you give depending upon the type of legislation you're dealing with. But the basic concept in terms of manifestly without reasonable foundation has not attracted that sort of international versus national difference, and one sees that from the range of cases in which it's been applied as a concept, including DA and FC itself. So, my lords, my lady, those are my submissions in reply, best I can assist further.
What do you say about the point that Mr. Birdling made, effectively whether or not it's open to you to get in? I mean, it's my fault for raising it. The question about whether there's a Section 3 interpretation which is available, because he's basically saying, well, if you'd run that argument below, we'd have asked for a declaration of incompatibility.
Well, my lady, I'm not going to stand on procedural ceremony. You've been asked to look at the compatibility of a piece of legislation. And if you've been asked to do that, then the legislative options are the legislative options. You haven't really got much option but to step into that territory. And I respectfully submit that it would be wrong not to consider the Human Rights Act consequences of that. You're only allowed to do the interpretation that Section 3 envisages if you find incompatibility. So my submission is you can't be shut out from that. It's simply a thing that the court will have to think about if it reaches that stage. And again, if we do reach that stage, and if you were to conclude incompatibility, then no doubt we could both give further submissions if that would be of assistance. But I'm not sure any of us would be saying you can't make a Section 4 because it's all gone. It's gone for too long. And obviously there are real advantages if you were to reach that stage in a Section 4 declaration being made, not least that it opens up a secondary legislative vehicle for fixing the problem.
Yeah. All right. Thank you, that's helpful.
No. Thank you very much. Thank you all very much for your submissions. We will obviously reserve our judgments. They will be provided to you in the usual way in draft for the very limited purposes of which you'll be aware. And we hope that once you've received them, including the point that was raised, you'll be able to deal with any matters by agreement. But if not, we will address them on paper. So thank you all again. Oh, and thank you very much for completing your submissions today.
A day and a bit.
Very small bit. Thank you.
Report back to table.